The Supreme Court has recently issued in April 2021 its decision on the challenge to the constitutionality of the Workplace Relations Act 2015 and the whole system of the WRC and the Labour Court and so on, and the determination of disputes, labour disputes, employment law disputes. Just by way of background, Mr. Zalewski, an employee who had been, I believe, unfairly dismissed, or he claimed he was unfairly dismissed, he brought a claim for that. He lost his case at the WRC, but he had a rough time at it, the WRC, to put it mildly. In fact, the Supreme Court decided that the way that that hearing was conducted, or certainly parts of it, were calamitous. But in any event, he challenged the constitutionality of the legislation itself and the whole WRC system. There was a judicial review in the High Court, and I think that was 2019. There was a decision issued then, and basically the decision was that it was constitutional, the system was constitutional, the legislation was constitutional, and the reason for that was because the WRC were not involved in the administration of justice. The claim had been that they were involved in the administration of justice, and the Constitution makes provision for justice to be administered by judges and in public, and neither of these things happen in the WRC. That was the basis of the claim, the judicial review referral to the High Court rather. The High Court decided WRC were not involved in the administration of justice. The reason for that was because if you got a decision from the WRC were incapable of enforcing that decision. You still had to go to the district court to get an order to enforce your decision. However, that decision then from the High Court was appealed by Mr. Zalewski and his legal team to the Supreme Court, and the Supreme Court have issued its decision in April 2021, on the 6th of April 2021, and it basically held that the system operated by the Workplace Relations Commission and the Labour Court is not unconstitutional. However, it does have concerns about certain aspects of the way that hearings are heard and certain procedures that are adopted. Just to give you a bird's eye view, as it were, the challenge was based on the argument that the system involved the administration of justice, and the Constitution provides that this can only be done by courts and judges in accordance with Article 34 of the Constitution. Because Article 34 says justice shall be administered in courts established by law by judges appointed in the manner provided by this Constitution, and save in such special and limited cases as may be prescribed by law, shall be administered in public. WRC hearings are not administered by judges, and they're not administered in public. Therefore, this was the argument as to why the legislation and the whole system was unconstitutional. The Supreme Court, however, held that the WRC was only exercising limited jurisdiction, and Section or Article 37 of Bunrock na hÉireann allows for the administration of limited jurisdiction, because it says nothing in this Constitution shall operate to invalidate the exercise of limited functions and powers of a judicial nature in matters other than criminal matters by any person or body of persons duly authorised by law to exercise such functions and powers, notwithstanding that such person or such body of persons is not a judge or court appointed or established as such under this Constitution. So the Supreme Court held that the WRC is involved in the limited administration of justice, and this is provided for in Article 37 of the Constitution. However, the Supreme Court did make a number of observations and findings that concerns it had essentially with the way that the procedures were adopted by the WRC, and did hold that two things in particular were unconstitutional. The issues it had, or the concerns it had, seems to me, based on reading the decision, to be on three things. One, evidence being given without the taking of an oath or affirmation. Two, the absence of a right, an automatic right to cross-examine a person giving evidence. And three, hearings not being held in public, being held in private. And the status quo, or the default position with WRC hearings, is that they are held in private. The WRC does permit cross-examination, but the legislation does not make express provision for this. So the Supreme Court had a difficulty with that. However, the Supreme Court did declare two aspects of the procedures unconstitutional. One, evidence being given without an oath or affirmation and no penalty for untruthful evidence, and two, the removal of the possibility of certain cases being held in public by virtue of Section 1413 of the Workplace Relations Act 2015 and Section 86 of the Unfair Dismissals Act 1977 are inconsistent with the Constitution. Just to summarise again, the Supreme Court did declare two aspects of the way the system operates to be unconstitutional. One, evidence being given without an oath being taken or affirmation, and two, the removal of the possibility of certain cases being held in public because the default position is WRC cases are held in private. The Supreme Court found that the underpinning legislation, the Workplace Relations Act 2015, was constitutional, but it does have concerns about these two particular aspects of the way of the legislation and indeed the way that the cases are held in the WRC, and the Supreme Court does expect changes to be made, does expect its findings to be acted upon, and therefore there is likely to be a significant impact on the future operation of the WRC and the Labour Court. It'll be interesting to see exactly how real teeth, as it were, is given to these observations and these findings of unconstitutionality by the Supreme Court. Again, the legislation itself, per se, Workplace Relations Act 2015, is constitutional, but two aspects of the way the system is operated is unconstitutional, and the Supreme Court does expect changes. So it'll be interesting, as I say, to see exactly how the WRC puts into effect the finding of the Supreme Court. In the Zalewski case, Mr. Zalewski, April 2021, the decision is handed down, and there is a link to the decision on my website, employmentrightsireland.com. If you find this video useful, I would appreciate if you gave it the thumbs up down below. Thanks a lot.